Justice Mendoza.
In your statement, Congressman, you mentioned about the repealing clause. Can you repeat that because I may have gotten it wrong?
I beg your pardon, Your Honor.
Repealing clause, you mentioned about the
repealing clause. What I said, Your Honor, is that under the repealing clause, just to support the statement that the RH law has an anti-abortion policy, the repealing clause says that prevailing laws on abortion are not repealed, modified, and let me just quote the repealing clause just to be very accurate about it, Your Honor. Section 29, Your Honor, says, except for prevailing laws against abortion and any law, presidential decree or issuance, executive order, letter of instruction, administrative order, rule or regulation contrary to or inconsistent with the provisions of this Act, including Republic Act number 7392, otherwise known as the Midwifery Act, is hereby repealed, modified, or amended. But that repealing clause exclude prevailing laws against abortion, Your Honor.
Thank you. How about Republic Act 9710, Magna Carta of Women?
Magna Carta. The reproductive health law is complementary to the Magna Carta of Women.
So, the provisions on women's health are not repealed or abrogated?
No, Your Honor. But let me just impress that there are major differences between the RH law and the Magna Carta of Women. And may I just enumerate?
Yes.
One, the RH law provides for universal access to RH information, care, and supplies. Then the RH law mentions about the Philippine National Drug Formulary and essential medicines. The RH law provides for issues on infertility and how to procure infertility. It also provides for honorarium for barangay health workers. It provides for a congressional oversight committee. It provides for a liberal interpretation clause. It provides for prohibited acts. It also provides for the joint responsibility of national governments and LGUs in the implementation of the law. And the procurement and distribution of family planning supplies are based on empirical standards. And then there is the requirement of full range of family planning methods in government hospitals and accredited health facilities, and also an annual maternal death review, which are not provided for in the Magna Carta of Women. And for a historical annotation, Your Honor, many of those conferees who signed the Magna Carta of Women said in writing that they are agreeing to the Magna Carta of Women provided that Congress should pass a reproductive health law.
So Section 17 is retained. I will read part of it. That in the provision for comprehensive health services, due respect shall be accorded to women, to women's religious convictions, the rights of the spouses to found a family in accordance with their religious convictions, and the demands of responsible parenthood, and the right of women to protection from hazardous drugs, devices, interventions, and substances. These are retained.
Those are provided for in the Magna Carta of Women, Your Honor.
Yes.
They are retained. As a matter of fact, they are contained in the Declaration of Principles.
Yes. In the rights of the spouses to found a family in accordance with their religious convictions. What is your reading of this?
That is a constitutional prescription, Your Honor, and that is found in the Declaration of Principles, Section 2 of the Reproductive Health Law. We truly abide by that provision.
That's good. In the RH law, there is a provision that in case of conflict between the one who is undergoing a procedure and the decision of the husband, conflict between the decision of the one undergoing procedure and the husband, the decision of the one undergoing procedure, of the procedure prevails. Is that correct?
Yes, Your Honor. With respect to certain surgical intervention, for example, a woman wants to have a ligation and the husband opposes it. Under the law, the woman should be, the decision of the woman must prevail. It is her body. And a woman is not a woman if she does not control her body.
Is this not inconsistent with the Section 17 that the rights of the spouses to found a family in accordance with the religious conviction? Is this not consistent? You are disregarding the decision of the spouse, the husband.
Considering that there is a conflict between the spouses, Your Honor, I think the one undergoing the procedure should prevail. And I think these provisions can be harmonized.
Maybe if she is undergoing an emergency to save her life, but this is tubal ligation. Your example is tubal ligation.
Yes, Your Honor. Despite the fact that it is tubal ligation, it is not life-threatening. The woman should be able to, the decision of the woman to undergo such procedure should prevail. It is her body, and she should control her body.
I'll go to another point. The RH law, in your comment in intervention on page 52, you mentioned the RH law is replete with provisions upholding the freedom of religion and respecting religious convictions. Earlier, you affirmed this with qualifications. Now, you have read, I presume you have read the IRR, implementing rules and regulations of the RH.
Yes, Your Honor, I have read, but I have to admit that it's a long IRR, and I have not thoroughly dissected the nuances of the provisions.
I will read to you one provision. It is section 5.24. This I cannot find in the RH law, but in the IRR it says, skilled health professionals such as provincial, city, or municipal health officers, chief of hospitals, head nurses, supervising midwives, among others, who by virtue of their office are specifically charged with the duty to implement the provisions of the RP-RH Act and DSUS, cannot be considered as conscientious objectors. Do you agree with this?
I will have to go over again the provisions, Your Honor.
In other words, public health officers, in contrast to the private practitioners who can be conscientious objectors, skilled health professionals cannot be considered conscientious objectors. Do you agree with this? Is this not against the constitutional right to the religious belief, to one's religious belief?
Your Honor, if there is any conflict between the IRR and the law must prevail.
Oh, thank you. You quoted in page 43 of your comment in intervention that during combined oral contraceptives, there may be changes in the endometrium. You mentioned, however, that there is no evidence that there is disruption of implantation. What do you mean by disruption of implantation?
Which means to say that there is a prevention of the fertilized ovum from being implanted in the uterus. Because although we considered that that could be a mechanism, which is third mechanism of action, until now, Your Honor, medical science has not validated that there is such a third mechanism of action.
So you are referring to the implantation, before implantation?
Yes, Your Honor.
You mentioned earlier that, or in your comment in intervention, that beginning of life is implantation. Am I correct? Am I?
Yes, Your Honor, but that is a personal opinion and at the same time based on medical authorities. But as far as the law is concerned, there is no need to resolve that particular issue. And I think the Honorable Supreme Court can adjudicate the issues raised by the petition on constitutionality without in any way adjudicating that particular issue, because it could be in the domain of medical science and authorities.
But do you agree with, but are you aware of ectopic pregnancies?
Yes, Your Honor.
So,
as a matter of fact, ectopic pregnancies are being used as an argument against the third mechanism of action, because the fertilized ovum can even implant on a more hostile venue other than the mother's womb or the woman's uterus.
so you agree with me that that is proof or evidence that there is life before implantation?
Your Honor, the fertilized ovum may be a living organism, but it is not a human being, it is not a human person, because the personality of a human person is determined upon birth, which retroacts to conception, depending on whether the fetus, the child is born alive after complete detachment from the mother's womb, or if the life of the if the intrauterine life of the child is less than 7 months, then it has to be alive for 24 hours after birth. You know, I think this should all be.
But it must be alive. So it was alive before.
Well, Your Honor, after conception, there is life there already. That's why the Constitution says the state shall equally protect the life of the mother and the life of the unborn from conception. But Your Honor, you were saying about fertilized ovum.
Yes. Anyway, I will leave it at that. Just one more. Are there now certified contraceptives or contraceptives certified by the FDA?
Yes, Your Honor. As a matter of fact, the Philippine National Drug Formulary has been in existence. The reproductive health law simply institutionalizes the use of this National Drug Formulary. And under the National Drug Formulary, there are already contraceptives certified by the Food and Drug Administration as legitimate, safe, and effective.
And if these are proven, proven evidence-based argument, that they are really abortifacients, can they be facially challenged now or subjected to a court case?
Yes, Your Honor. The FDA has been given the competence in a previous law creating the FDA to determine the legality and whether these are medically safe or not, these contraceptives. And this is reiterated in the reproductive health law, because under Section 10, the FDA is mandated to release guidelines on the use of contraceptives, particularly considering their effects.
Okay. So, in your page 48 of your comment and intervention, you mentioned, you stated that if it is subsequently ascertained that contraceptives prevent the implantation of the fertilized ovum, then under the RH law, the FDA can determine such secondary action as abortive.
Yes, sir. That is the definition of abortifacient under Section 4A,
So-
which is a formulation of the critics of the RH law, which we accepted.
So if the FDA determines such secondary action as abortive, can the FDA or will the FDA certify it as, or can it ban it?
Yes, Your Honor. If a device or drug is determined by the FDA to prevent the fertilized ovum from breaching or implanting in the mother's womb, then that is considered an abortive patient under the definition of Section 4A. Although, as of now, that has not been validated, and we would... the beauty of this law is it is even anticipatory of a possible third mechanism of action of contraceptives, which would be considered abortifacient.
Thank you very much, Congressman.
Thank you, Your Honor.